Everybody can be great, because anybody can serve. You don't have to have a college degree to serve. You don't have to make your subject and your verb agree to serve. You don't have to know the second theory of thermodynamics to serve. You only need a heart full of grace, a soul generated by love.
Members of boards, commissions, and committees provide an important service to our community by advising the Board of Supervisors on a wide variety of complex and significant policy issues and programs.
Serving on a commission can be a rewarding experience. It's an excellent way to participate in local government and make a personal contribution to the community. Serving on a commission also requires you to familiarize yourself with the legal requirements relating to the conduct of public business.
The primary purpose of a county advisory commission is to serve as an advisory body to assist governmental entities in the decision-making process. Commissions serve as conduits for public input by gathering, analyzing, and recommending options to the Board of Supervisors. Some commissions are mandated by federal or state statute, or are established by county ordinance or resolution. With a few exceptions, the Board of Supervisors usually retains the final authority for policy decisions. For most commissions, there is an establishing ordinance, resolution, or legal mandate that outlines the scope, function, mission, and purpose of the commission. Each commission should have a set of bylaws that define the way they operate. These documents are very useful in orienting new members to the specific charge and focus of the assigned commission. The Board of Supervisors has adopted a resolution establishing standing rules and application and appointment procedures. This document is one every commissioner should review carefully, as it clarifies board policies and the roles and responsibilities of commissioners. It can be found in the commission handbook you received when you were appointed. All appointed commission members, whether new or reappointed, must take a loyalty oath of office administered by an authorized county representative before they may vote on any matter presented to their commission. Certain commission members must complete and file all necessary documents required to conform with the Political Reform Act of 1974 and are subject to all applicable California laws pertaining to conflict of interest. Fines can and have been levied by the Fair Political Practices Commission for failure to file.
All in favor signify with aye.
Madam Chair, before we vote on this matter, I would like to point out that my husband is employed with Arden Corporation, so perhaps we could continue this till the next meeting so that I have a chance to confer with County Council about a possible conflict of interest.
A conflict of interest applies when a decision may have a positive or negative impact on the personal income or assets of a commission member or on the personal income or assets of their spouse or dependent children. Commissions are also responsible for conducting public business for the County of Marin, subject to all applicable policies regarding non-discrimination. Commissions act only as advisors to the Board of Supervisors and must not knowingly misrepresent the scope of their influence or authority to any other commission, outside agency, the press, or the general public. This includes the use of unauthorized business cards or county stationery. No person appointed by the Board of Supervisors to a county commission shall at any time make improper use of any stationery or business card appearing to constitute an official business card or stationery of the County of Marin. Only the Board of Supervisors may take action to create official county policy. Furthermore, although commissions may make recommendations to the Board of Supervisors regarding specific applicants to fill vacant positions on their commission, the board retains full authority in selecting and appointing new commission members. Commission meetings are by definition public meetings and therefore are subject to the rules set forth in the Public Records Act and the Ralph M. Brown Act.
All in favor of forwarding the committee's recommendations on to the Board of Supervisors, please say aye. 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 Thank you.
Excuse me, Madam Chairperson, may I please have a copy of the committee's report?
Records of public meetings, as well as other public records, are open to inspection by any member of the public with certain exceptions. For complete details, a copy of the Public Records Act, or advice on a specific situation, contact the County Council's office. Local legislative bodies, such as boards, councils, and commissions, are created in recognition of the fact that several minds are better than one, and that through debate and discussions, the best ideas will emerge. The law which guarantees the public's right to attend and participate in meetings is the Ralph M. Brown Act, which has regulated the conduct of public meetings in California since 1953. The Brown Act declares that public commissions, boards, councils, and other public agencies exist to aid in the conduct of the people's business. It is the intent of the law that their actions and deliberations be conducted openly. The Brown Act applies to public commissions, boards, councils, and other public agencies. But just how does the Brown Act apply, and who does it specifically apply to? Any congregation of a majority of the members of a legislative body where they discuss, hear, or deliberate on any matter within their jurisdiction is governed by the provisions of the Brown Act. It also applies to standing committees which involve less than a quorum if those committees have a continuing subject matter or a meeting schedule fixed by charter, ordinance, or resolution of the legislative body. But this doesn't just include formal noticed meetings.
You know, I'm glad I caught you both here at the table today. I was thinking about the proposed rules for the dog walkers coming up at the next meeting. I think we need to talk about those issues.
Commission members are not allowed to discuss any business that falls under their jurisdiction as a legislative body while a majority of members are present, even during lunches, social gatherings, or board retreats. While all or a majority of commission members may attend such conferences or social or ceremonial occasions, members may not discuss among themselves any issues specific to their commission.
Hey, I wanted to talk to you regarding this dog walker item coming up at the next meeting. Yeah, that one. Perhaps after our discussion, I'll call the other members and talk to them as well to get their feelings on the subject.
Serial meetings are prohibited by the Brown Act. A serial meeting is any series of communications in person, on the phone, via email, or any other media, each of which individually involves less than a quorum, but which taken as a whole involves the majority of the board's members.
Hey, good morning, Commissioner Jones. This is Commissioner Smith. How are you? Doing well, thank you very much. Hey, you know, I want to talk to you. I'm interested in polling the members of the commission to see how you're planning to vote on the dog walker issue at the next meeting.
Furthermore, straw votes, either in person, by phone, by email, or any other method, are strictly prohibited.
Yes, Mr. Smith?
Oh, Sally, I need you to place calls to all the other members of the Parks Commission and find out how they plan to vote on this dog walker issue coming up at the next commission meeting.
Assigning an intermediary to conduct a straw vote is also prohibited by the Brown Act. All such discussions or deliberations must be conducted during a public forum.
The Brown Act requires that certain minimum requirements be met for public meetings. At least 72 hours prior to a regular meeting, an agenda which contains a brief general description of each item to be discussed or transacted must be posted in a location which is accessible to the general public. This includes notice of standing committee meetings. Special meetings are called by the presiding officer of the board or commission and require that a notice must be received at least 24 hours in advance by all members and by all media outlets that have requested notice in writing. No business other than that for which the special meeting was called may be considered. There are some exceptions to these rules. However, each of these meetings must be publicly announced before proceeding with the meeting. These exceptions are: emergency meetings may be held when the majority of the body determines that a true emergency exists, a work stoppage, crippling disaster, or any activity that severely impairs the health or safety of the public. At least 1 hour prior to the meeting, telephonic notice must be provided to all media outlets which have requested that they receive notice of any special meetings. Urgency actions may be taken during a regular meeting when the body determines that the need for immediate action on the item not on the agenda arose after publication of the agenda and cannot reasonably wait for the next regularly scheduled meeting. Urgency actions to add an item to the agenda require a 2/3 vote of the entire body, or if less than 2/3 of the entire body are in attendance, then a unanimous vote of the remaining members is required. Where an item has been properly posted on the agenda for a prior meeting, the item may be continued to a subsequent meeting that is held within 5 days. Under these circumstances, the items need not be posted for the subsequent meeting. A few other requirements must be met. Notice of all meetings must be posted in a place that is easily accessible to the public. However, ad hoc committee meetings do not require noticing. A subcommittee or ad hoc committee, which consists of less than a majority of the commission and which has neither continuing subject matter jurisdiction or a meeting schedule fixed by charter, ordinance, resolution, or formal action of a legislative body, is not subject to the Brown Act. Actions, whether a motion or a vote, may only be taken on items included on the properly noticed agenda and when a quorum of the commission is present to vote.
I know the matter that's before us has been somewhat controversial, so let's take some paper and write down our vote and then hand them to the secretary to count.
Because the public's business must be conducted openly in front of the public, the Brown Act specifically prohibits secret ballots and proxy votes.
Meetings must be accessible to all without reservation. Meetings may be audio or videotaped by any person so long as this action is not disruptive to the meeting. Each agenda must contain an opportunity for open time to give members of the audience a chance to speak about items not on the agenda. Reasonable time limitations may be placed on the speakers. It's important to note, though, that no action may be taken on any matter raised for the first time during open time, since the item is not on the agenda and therefore no public notice of the pending action has been made.
Good morning.
Good morning.
I'd like to address the construction of the new ball field at Stafford Lake Park.
Sorry, that's not an appropriate subject for this meeting.
It is a breach of the Brown Act to prohibit a member of the public from speaking on any subject during open time. Further, public comment must be allowed on all agenda items, except during closed session. A well-prepared agenda contains the following: an accurate description of each item up for information, discussion, or action before the Commission. The description should be brief, generally no longer than 20 words, and closed session items should also be included. Remember that no discussion or action can be taken on any item not appearing on the posted agenda unless an urgency finding to add the items is approved by 2/3 of the entire body. Every agenda must include open time, an opportunity for the public to speak on non-agenda items. If a closed session item is scheduled, it must appear on the agenda with a brief description. We will discuss closed session matters in more detail later. No member of the public can be required to sign a registration list in order to attend a public meeting. It's okay to have a list, for example, a mailing list for interested persons, but it must contain a notice that there is no requirement to sign it. Public criticism of committee members must be allowed. However, it is permissible to exclude disruptive persons if they make it impossible to conduct the meeting.
Okay, that's it for our closed session discussion on employee negotiations. Before we go back into open session, let's see if we can reach some agreement on the budget matters we discussed earlier.
Closed sessions are limited to certain matters only.
Personnel matters may be discussed, employment or performance evaluations, disciplinary actions, misconduct. In certain cases, the employee alone has the option as to whether these items may be discussed in closed or open session. An example of a personnel matter which might be discussed in closed session is Gillespie versus San Francisco Public Library Commission. The Library Commission conducted a closed session meeting to consider appointment of a new city librarian. Although the mayor actually makes the appointment, the city charter requires the Library Commission to participate in the appointment process. The court held that the commission's closed session meeting under the personnel exception for the purpose of nominating 3 candidates for consideration by the mayor was proper. This personnel exemption only applies to considering public employee appointments, evaluations, discipline, dismissal, or release, and is not applicable to considering applications for appointment to a board or commission. The Act provides for closed sessions to enable a legislative body to meet with its negotiator concerning discussions with employee organizations and unrepresented employees regarding salaries and fringe benefits. However, prior to the closed session, the body must meet in open session and identify its negotiators. Real estate negotiations, pending litigation, insurance liability, application from a person with a criminal record, and any item where discussion in open session would jeopardize the public safety. After closed session, the Commission must reconvene in open session and report on any action taken during closed session. If no action was taken, this must be announced as well. Intentional violation of the Brown Act is a crime that can and will be prosecuted. Either interested persons or the district attorney may seek to have actions taken in violation of the Act declared null and void by a court. Additionally, you may be liable for civil penalties including injunction, mandamus, and declaratory relief. Furthermore, attorney's fees and costs may be awarded to the other side.
The information presented in this video serves to highlight the critical responsibilities of county commissioners and further serves to ensure that government proceeds in an accessible and open manner. If you have any questions or concerns, feel free to contact our office or the County Council. Above all, thank you for serving your community.
Hello, the Board of Supervisors recognizes the level of commitment and professionalism it takes to serve on our boards and commissions. Your service helps our county government be more representative and responsive to the community. Thank you for your willingness to serve.